SJC-12705, Wenda Aquino v. United Property and Casualty Insurance Company.
Mr. Hochbaum, good afternoon.
Good afternoon, Your Honor. May it please the court. My name is Seth Hochbaum. I'm appearing on behalf of Wenda Aquino. As an innocent co-insured, Ms. Aquino is entitled to coverage, and Judge Wilson properly so found. As the court well knows, Chapter 175, Section 99 prescribes the mandatory fire insurance policy in the Commonwealth and has done so for more than a century. This court held in Ben Elfman and the appeals court held in Zechel that there cannot be any deviation from that standard form. Nonetheless,
I understand that, but I may have misread your argument, but the deviation makes clear sort of what the law is, which is that if they'd used the proper language, it would be the same test, wouldn't it, under Cozier, that if one of the insured intentionally set the fire, no one could recover. So I'm not sure if they'd used the proper language, wouldn't it have been the same test?
Well, the test here is, first of all, they did not use the correct language.
I'm a little mystified by why it's so important that they change the language when under the statutory language and the case language, it's the same result.
Respectfully, Your Honor, it's not the same result.
Well, but it isn't, again, if they'd used the proper language, wouldn't, under Cozier, whatever that case is, that old case, wouldn't the standard be that you don't recover?
No, because in Cozier, the argument that was made by the innocent co-insured there is very different than the argument that I'm making here.
But the Cozier interprets the statutory language, the statutory insurance provision that you say should have been written to say that you don't recover if you set a fire.
Cozier did not interpret the statutory language. What Cozier did is it...
Result certainly did that. I know you have a fine distinction, but it says that, doesn't it?
The language in the Cozier policy did use the words "the insured," but the court in Cozier was not presented with an equitable argument, not the legal argument that I am making here, and that makes a world of difference. The equitable argument that the insured in Cozier was making 81 years ago was that the court should read into the policy as their interest may appear. That is not what I'm arguing here. What I'm saying here is that the words "the insured," as used in Chapter 175, Section 99, as opposed to "an insured," as used in the UPC policy, makes a difference, because "the insured," as the statute repeatedly and exclusively uses throughout, means only the insured, him or herself, who caused the fire, not the innocent co-insured, whereas "an insured," as is used in this policy.
Which case says that? Which Massachusetts case says that that's the meaning of "the insured" under the statutory provision?
We have the Gonzalez case, which is Gonzalez versus Liberty Mutual, which is Judge Lang. The Hall case, Judge Ferrara.
These are Superior Court cases?
Yes.
Any appellate? This statute's been in effect for how many hundred years?
It was first enacted, I believe, in 1873.
So we've got a fair amount of time here. Any appellate cases say that's the meaning of "the insured"? Because Cozier says the exact opposite. So any appellate cases, I don't care what Justice Lang said in a Superior Court case. Any appellate case?
We have those two Superior Court cases and Judge Woodlock and Shepperson most recently.
Is that what he said? Is that what Judge Woodlock said in that case? Or is he makes that point?
Judge Woodlock does make that point. He concurred with Judge Lang and Judge Ferrara in agreeing that "the insured" refers solely to the culpable insured. I'm sorry, no, it's the other way around. The insured is divisible, separable, right, whereas "an insured" is, potentially both of the insureds, including the innocent co-insured. So all three of those judges did grapple with the language that the court is now
They
being
come out to
confronted with.
the opposite conclusion or the same conclusion? When they sever the, do they say that you can recover?
When the word "the" is used, the innocent co-insured can and should recover, because "the insured," as used in the statute repeatedly, means only the culpable insured, not the innocent co-insured. Where the word "and" is used, as is used in this policy here, it means potentially both. And in fact, the policy itself makes that clear. If the court looks at Volume 1, page 38, which is the policy itself, or one of the pages of it, the policy that UPC issued makes it clear that "an insured" means one or more of the insured, and that is proscribed by statute. I would also just comment on Kosier, since it's come up, that as Judge Wilson correctly found, Kosier, though it did briefly reference Chapter 175, Section 99, did not do any kind of analysis of that statute whatsoever, which the court is now being asked to do. So it's really, I would argue, confined to its facts. It did not address whether Section 99 requires broader coverage, which I respectfully submit to this court it does. And that's the issue now before this court. And as the Iowa Supreme Court discussed in Vance versus Pekin Insurance Company, it's 457 Northwest 2nd, 589, Kosier is among those older cases where historically a husband and wife were treated as a single entity. There was no focus, as there is today on the recent trend of cases nationwide, on the effects of imputing the arsonist's conduct onto the innocent insured. And also there was no discussion at the time Kosier was issued 81 years ago about whether it did or did not conform with the statute, which again is the heart of this appeal.
There's something which no one in any of the briefs has discussed, which I'm perplexed by. In Kosier, the question was the voiding, the policy shall be void. It was not an exclusion, it was the voiding of a policy. And basically it says if one insured defrauds the company, then the policy is void. And if the policy is void, then neither of the insureds can recover. Section 99 has a policy about shall be void, but nobody is discussing whether anyone is claiming that that provision of the policy was violated. What do we do with this distinction between the voiding of a policy versus the exclusion of recovery?
Well, here we have in this case, unlike in Kosier, and this is, I guess, another distinction between Kosier and this case, because in this case, as Your Honor is correctly commenting on, is that the objectionable language is found in an exclusion, which, as the court knows, is to be interpreted very narrowly and strictly. So we have here a non-compliant exclusion, which illegitimately or improperly, I should say, restricts coverage that is mandated by statute. If I could just...
So, I mean, the void in policy, I'm looking at Section 99, and I note that UPS or UPC has not invoked it, but is there any claim that any of the insureds here willfully concealed or misrepresented any material fact or circumstance regarding the insurance or the interest of the insured, or in case of any fraud or false swearing by the insured? Do we have any of that even by the fiance who died here?
No. The denial of coverage was premised on the arson, not on any other misconduct or fraudulent misstatements or anything of that sort. So it was strictly the arson, the intentional act committed by the decedent only. That was the denial of coverage, nothing else. And by agreement, I should comment, of course, that Ms. Aquino was not at all involved with that, was not complicit or aware of any of that.
I think we understand that. Can I ask another question? Relates, I guess, to the second issue of the whether she gets half or gets whole, if she were to get any. She's a tenant in common.
That's correct.
Okay, so let us imagine in this case that the fiancé did not set the fire but died in the fire. What would the check say from the insurance company in terms of who would get paid for the full recovery from the home?
It would be Ms. Aquino, the legal representative of the decedent estate, and the mortgagee. But that is not, those
So
of
it would
course
not
are
be that the estate would not get any part of it?
No, if Mr. Pastrana,
Let's assume Mr. Pastrana was blameless in all this. Let's assume he just died in a fire that somebody else set. Would she have gotten half and the estate have gotten half, or would it have been a check to each of them for each of them to sign? I'm trying to figure out how that would have worked for a tenancy in common.
well, I think for this notion that it was a tenancy in common, if I could just address that particular point, I think that that is not the determining factor in terms of whether she gets half or 100%. And I make this point repeatedly in my briefs, that we have to look at the insurable interest of Ms. Aquino, not her equity or ownership interest in the property. And if we look at the insurable interest, as UPC itself admits, she did have an insurable interest. Clearly, she lived there and received a benefit from the property and suffered a loss when it was destroyed. She also had the use and enjoyment of the entire property, even if her ownership was half. It was a 1/2 or a fractional interest in the undivided whole, and she had, as I said, use and enjoyment of the whole, and she had an interest in preserving the whole of the property. And it was the whole of the property that was destroyed by fire. So she lost her entire insurable interest. So she lost more than just her 1/2 ownership interest. Ms. Aquino lost her entire insurable interest. And what Judge Wilson's decision does is improperly sever the recovery by the innocent co-insured, and in so doing, it completely frustrates the purpose of fire insurance policies in the Commonwealth, which this court has recognized going as far back to Wayner in 1891, which is to provide a personal contract of indemnity. And as this court also held in Kingsley in 1937, is the fire insurance policy is intended to restore the insured to the position she occupied immediately prior to the loss and hold her harmless for her loss. By giving Ms. Aquino 1/2 of the insurance proceeds, she is restored halfway towards meeting those objectives.
Is there any guidance in the appellate case law on this at all? Because Justice Wilson's dealing with a complicated issue, but is there any case law on how you do this?
In terms of the halving of the
Yeah.
recovery, there is nothing from the Commonwealth. There are plenty of cases that I cite in my briefs, including, just by way of example, the Scindra, SCINDRA, Alabama Supreme Court case from 1951.
But we have no Massachusetts.
Those cases go both ways, though, right?
There are cases that go both ways, and both parties cite them going both ways.
But we have no mass cases that deal with this kind of division of insurance proceeds?
None that I could find, no. And this is an issue of, in terms of the halving, this is an issue, I believe, of first impression. But we do have the guidance, as I said, of this court's decisions that go back more than 100 years in terms of what is the purpose of a fire insurance policy, and is that purpose going to be fulfilled if the innocent insured only gets 50% of the recovery? And respectfully, I would submit the answer to that is no. It doesn't do justice to the innocent insured to get 50 cents out of 100 when she, in this case, by agreement, has suffered a total loss.
Yeah, but shouldn't it be all or nothing, and that the purpose of insurance, fire insurance, is to rebuild?
The purpose of fire insurance is to
Not
rebuild.
to halfway rebuild.
Right, so she can't build half of a house and get half of a toilet and so on. It just leads to a preposterous result, and that's what we have here. And I would also just observe that, you have somebody that has a mortgage on a home, just by way of example. She's jointly and several liable on the mortgage, so she's got to pay 100% of the mortgage, but only gets 50% of the insurance proceeds. And I think it really just drives home the point That the result that was, that we have currently in this case just is inequitable. It just doesn't ring true or make sense. I see that my time is almost up. I don't know if the court has any other questions.
I have one that's just, it may not be particularly relevant to anything, but I know fire insurance statutes change over time.
Yes.
When Kosher was decided, is it the same fire insurance statute as we have now?
The statute changed in 1951, so about 13 years after Kosher was decided. But as best I can tell, the words "the insured," which are the operable words in this case, were in effect even preceding the 1951.
There's no legislative history on this as to the and an?
There's the appeals court case, I'm drawing a blank on its name right now, that talks about the legislative history of it, but as best we can.
I think I wrote that one.
Your Honor knows.
Well, I don't know it, I just, I remember it. I have a vague memory of having written it.
Okay, thank you.
Okay, thank you.
Mr. Hassett.
Good afternoon, Mr. Chief Justice, Associate Justices, David Hassett on behalf of UPC with my colleague Michael Melville. If I could just start with the last remark that my brother made, because I think it's really a misdirection, and under the statutes and under our law, the mortgagee bank gets paid separately. It's a separate analysis. It's actually the subject of some litigation in this case. But to determine what's equitable and what's fair based on a mortgage, actually it's quite to the contrary, that any payout at all that Ms. Aquino gets is going to be, in part at least, getting rid of any mortgage, because without respect to fault, the mortgagee would get paid first. But going back to...
But isn't Justice Gaziano's question right then, that we shouldn't be dividing this up? It's all about insurance proceeds to rebuild the house, right? Isn't it an all or nothing? Do you agree that it's an all or nothing?
No, not at all, Judge.
Do you accept this idea that you can split this in two?
Judge, every jurisdiction that's looked at this, the vast majority of jurisdictions that have looked at what should the payout be, if any, is 50%. Obviously, Judge Wilson did it in our case and limited it to 50% of the policy. But the vast majority of cases, with maybe one or two exceptions throughout the country, when they indeed pay out to the innocent insured, it's limited to 50%. And the basis for that is policy reasons, certainly. They don't want a windfall to have the innocent co-insurer have a windfall. In this instance...
How is that a windfall?
Yeah.
Just how is that a windfall for the innocent insured who's lost what she had before the fire?
And made payments.
Yes, well, first of all, and I think Judge Gantz alluded to this, it's tenancy in common. So there's no right of survivorship. So the part of the property that's owned, she only has half of the property in terms of the tenancy in common, number one. That's number one. Number two, it's a contractual issue, and there is policy language with limitation of liability as to the named insured's interest in the policy. So the outcome with respect to if there would be a payout, what would it be? 50% is the best outcome, because otherwise you run the risk of having a arsonist who doesn't die in the fire, either posthumously, if he does die, obviously his heirs would get that benefit, or if he doesn't die and the money goes into the house and they rebuild, he has an interest in that property. In a lot of the cases we cite in our brief address that very public policy concern. But if I may go back briefly to Kosior, the Kosior decision is very clear.
We'll get to Kosior in a second. So
Yes,
but
Your Honor.
let's stick with this issue. So I'm going to ask you the same question I asked your brother. First of all, is there anything in the policy that says this is a tenancy in common as opposed to a tenancy by the entireties?
I'm sorry, Judge.
Does the insurance company know, I mean, would the insurance company know that it's a tenancy in common as opposed to a tenancy by the entireties?
No, I think, Your Honor, when my brother alluded to how would a check draft be issued, if there's no dispute and you have two named insureds and there's a complete loss, What you would expect is that both of the named insureds would be on the draft to the policy limit based on whatever examination of damages there were.
So if he had died in the fire and was blameless for it, you would first pay whatever the mortgage, the amount that was paid would first go to pay off the mortgage, correct? Which the deceased could have been a co-mortgagee on, or
Correct.
co-mortgagor. And then with regard to the balance, it would be paid to Ms. Aquino and Mr., I forget his name, the fiancé. If he were, well, I'm sorry, if he had died, it would go to, you say it would go to her alone, or would it go to her and the estate?
Yes, Judge, I think following that scenario, it's Pastrana, Your Honor. He's the one that did die, in fact, he's the
Right.
fiancé.
Right.
It would, in theory, reach ultimately to his heirs and/or under his estate or representative.
What would your check say if he had died and was blameless? The check, the balance after the mortgage is
Administrator
paid?
of.
Sorry?
It very well could be administrator of or executor of the estate of,
So it would say Ms. Aquino and the administrator of the estate of, and
particularly
both would
here,
have
Your
to
Honor.
sign
That's what I
off.
would expect.
Both would have to sign off on the check.
Oh, yeah, and if there's an estate, whoever the representative was that had been appointed would sign off on the check. And I think all the cases that have looked at this have come down to the distinction we have seen is whether it's half of the policy or it's half of the damages up to the policy. And in this instance, the Judge Wilson found that it's appropriate for it to be half of the policy. One of the reasons for that, and I think it's a critical reason, Your Honor, Your Honors, is that if you're going to have the innocent insured collect against the case law, against Cozier, so if you're going to go against Cozier, allow an innocent insured to collect, to do that, you would have to determine that the is in fact severable. In other words, it's not joint as Cozier determined. The Cozier court determined the means the insureds. So the idea contractually was when the insurer on one side of the table said, I'll agree to insure this loss at this location, your home, and you two who live there signed it, the understanding was neither of you can burn it to the ground and come back and collect on it. So if one does it, nobody can collect on the loss. That's what Cozier says.
But Cozier was focusing on the provision of the policy which says the policy is void.
Yes, Judge.
And you've not, and I understand that if the policy is void, then nobody collects on it,
Correct.
because the policy is a nullity. But you're not claiming that this policy is void.
Well, Judge, what we're saying based on the language in the statute 17599 and in our UPC policy is that it is an exclusion that does not permit recovery. And the way the statute reads is not liable for damages caused by neglect of the insured to use all reasonable means to save and preserve the property. This company shall not be liable while the hazard is increased by any means within the control.
I understand, but you're not claiming that the policy is a nullity because of the conduct of Mr. Pastrama. You're claiming this policy still exists, but there's an exclusion that prevents him from receiving any of the money, or actually prevents her from receiving any of the money.
The way the policy is drafted, yes, Your Honor, that's the language that excludes the innocent insured from recovering.
So, but even if we were to say kosher is still good law, would it apply only to fraud committed by an insured which voids the policy? And you're asking us to extend the meaning of kosher to include not merely the voiding of a policy by fraud, but also the exclusion of recovery from an innocent insured.
Judge, I am asking the court to look at the term of the word "the" as used in Cozier and apply it jointly so that the innocent co-insured is unable to recover when one insured commits arson and destroys a property. If I could read from Cozier, We think the policy in question was joint and that the plaintiff cannot recover. The act of her husband in burning the insured buildings was an act of the insured, and as such, it was a fraud upon the defendants which rendered the policies void in accordance with their terms, as you have said,
Well,
Judge.
of course, if the policy is void, there's no policy.
But the
So-
result-
So no one can recover, but here there is a policy.
There's a policy, and it's more narrowly saying that the innocent co-insured does not collect when the insured or co-insured intentionally burns down the property. And Your Honor, if I may,
So is the intentional burning is the fraud, not any kind,
yes,
not
the-
kind of misrepresentation.
it's not the misrepresentation. It may or may not come under the umbrella of failing, neglecting the premises, but I think it's the fraud itself as well as
Did the old,
increasing the hazard.
did the old statutory mandated provision use the word fraud in it?
Yes, it did.
Because is that why the court focused on this fraud and nullifying the policy? Was this more tracking the old statutory language?
It's both, Judge. It's tracking that fraud language, and I would add another provision that we put in our brief that also supports the language used in the UPC policy. It says, "This company shall not be liable while the hazard is increased by any means within the control or knowledge of the insured," which appears to be a little bit more on point when the insured intentionally burns down the property. We are not alleging there was a misstatement or concealment, and we're certainly not alleging that Aquino was part of it. We're conceding that she, in fact, is an innocent co-insured in all of this. And then, Your Honor, I would add that the legislative intent here is a very significant issue when looking to what is going to happen going forward, because the policy, and my brother, the last argument raised it with respect to a reenactment of a statute. So this policy, the New York policy that was adopted in 1951, used the same terminology. And Judge Kafka was asking my brother about it. Basically, they used they continued to use knowing, in this court needs to be in a position to adopt construction of legislative intent, that the legislator knows what these courts, any courts have said about definitions. The legislator adopted knowing that this court had said is joint.
Except
So-
for it wasn't in connection with this actual statute, right? I mean, there was no interpretation of the statute in Cozier.
This is I would qualify this as a subsequent enactment of the same standard fire policy. It's a New York fire policy, and the relevant terminology contains the same language, So in terms of it being a separate statute with no connection, no. In fact, it follows the previously enacted statute with some changes in 1951. And so by doing that, the legislature knew that they weren't going to be changing, limiting, adding anything to this interpretation, because this court had clearly said, if somebody burns down the house that lives in the house that's a co-insured, nobody's collecting on that. The legislature knew that 13 years before the statute was in fact enacted, and they didn't elect to change it to a different word that would in fact protect the co-insured. So the basic fundamental construction of legislative intent here supports the understanding that the legislature knew when it used the word in term that an innocent co-insured would not be able to collect. And there couldn't be any clearer decision than Cozier, and it's on point. The couple in our case,
I'm
they were...
confused. It was in response to Justice Budd's question, so was the legislation, the mandatorily required insurance provision was not in place when Cozier was decided? Or was it?
Yes, it was.
It was.
It was a different provision.
Was a prior statute in place, it was the prior statute in place that then got replaced or reenacted after they adopted the New York fire standard policy, which many states did at the time.
Do we have cases that are just limited to the New York kind of statute in determining what the and and mean?
The cases that we've cited relative to the meaning yet, Judge, the
Yes, that's right. Are they just those involving the New York kind of insurance that we have in Massachusetts?
No, they're using the same language as we are now, obviously, because it's enacted, but there's no specific other case. Massachusetts had this decision at the time. I'm not aware that New York did at that time.
My memory, ugly as it is that there were 3 different kinds of basic fire insurance policies in the nation, and that Massachusetts has one of them, and I think it's the New York kind.
Yes, it is. That's
And
correct, Your Honor.
So that sort of, I think, narrows the field in terms of interpretation of statutes. So if you're going to look at the and what it means, I think you just looked at the New York sort of cases, wouldn't you?
No, we didn't cite any specific ones, Your Honor.
All right, okay.
So let me, I guess, ask the basic issue. Your insurance company is innocent. You did nothing wrong. Mrs. Aquino is innocent. You did nothing wrong. Who should suffer?
Judge, I think the insurance company, if they're guilty of anything, was being very transparent in their language.
But, well, I mean, you actually, there's a separate issue is they claim you're guilty of not mirroring the policy. Put the 93A issue aside. I guess the question is, if Mrs. Aquino is innocent and isn't insured, why should she suffer for what her fiancé did when what her fiancé did not void the policy?
Because, Judge, it works as an exclusion in that the is considered joint in that one action.
I know you're referring, I mean, but the question is, in terms of what the legislature meant to do, who, in your view, did the legislature mean to, which innocent party did the legislature mean to bear the burden here? You're claiming that the legislature wanted the innocent co-insured to bear the burden and not the insurance company to bear the burden.
Absolutely, Judge, because there's coextensive in their obligations to the insurance company, and the one promise they're making is the house may get struck by lightning, somebody else may burglarize it and burn it, but we, the named insureds, can't burn it down and then collect on the policy.
But you understand that in Cozier, the court found that there was, that Mr. Cozier burned it down with the intent to defraud the insurance company.
Yes, Your Honor.
And we don't have that here, do we?
Judge, we have an intentional act, and that's
We
what
have
we
an intentional
have.
arson, but we don't have any intent to defraud the insurance company.
Judge, I'm not sure if it is that clear. I want to take that back. I understand there's fraud, but I don't know whether or not the record in Cozier was developed to say defraud just the insurance company, but I will say in cases where they've been...
I mean, I'll read it. While the policies were enforced, the buildings were damaged or destroyed by fires, which were set by the husband with intent to defraud the defendant companies. So in
Okay.
Cozier, you have that intent. I gather you're not since you're not claiming that the policy's void, you're not claiming fraud on behalf of Mr. Pastrana.
No, we're not saying fraud in the sense of intentionally at that moment, Judge, and based on the facts of our case, it wouldn't support necessarily in our case that they would do that, but a number of other cases addressing this issue haven't limited either the exclusion or the limitation of recovery by the innocent co-insured to whether it was intentionally fraud or not. In our case, it appeared to be an angry situation, involved a handgun, so that's a separate issue, I agree, Your Honor. But in this case, Your Honor, I think at the end of the day, what we're looking for the court to determine is that it's a joint obligation relative to the responsibilities of the named insureds to the contract, and getting back to the first issue we had, which was what happens to the payout, I should note, or I'd like to note, that this is going to be a situation where even if the innocent co-insured doesn't get a direct check, the property is there, that will be owned without any encumbrances based on the mortgagee being in line to obtain whatever there was for purposes of a mortgage on the property. So it's not that nothing is obtained through all this. It's just that there isn't an affirmative check for all of the damages, which is what my brother would like.
Although pragmatically, depending on the size of the mortgage, if she doesn't get enough money from the insurance company, then they'll foreclose on the mortgage, and the bank will end up owning the property.
Depending upon the amount of the mortgage, Your Honor.
Okay, thank you.
Thank you.